Tēnā koutou katoa e mātakitaki mai nā. My name is Claudia Geiringer, and I hold the chair in public law at Te Herenga Waka, Victoria University of Wellington. Although in just a few days' time, on the 2nd of May 2022, I'll be taking 5 years leave to serve on Te Akamatua o Te Ture, New Zealand's Law Commission. What kind of Bill of Rights is the New Zealand one? This is the question that unifies much of my scholarship. In the history of human rights protection, it's hard to imagine any other instrument having attracted quite so many answers to that question. Epithets of and metaphors for our Bill of Rights abound. It's a statutory Bill of Rights, an interpretive Bill of Rights, a parliamentary Bill of Rights. It's a partial Bill of Rights. It's a rogue's charter. It's an instantiation of a dialogue model, a new Commonwealth model, a weak form judicial review model, a model of multi-stage rights review. It's an instrument of ordinary law, of constitutional law, of ordinary law masquerading as constitutional law. It's an inflationary Bill of Rights. It's a Clayton's Bill of Rights. It's a Trojan horse. And on it goes. Not all these representations of the New Zealand Bill of Rights are in conflict with each other, but some clearly are. And together they underline a degree of contestation and uncertainty surrounding the Act's significance that's been much remarked on over time. For example, Bill of Rights scholar and practitioner Paul Rishworth QC has suggested that in the pantheon of human rights documents worldwide, the New Zealand Bill of Rights is uniquely hobbled by uncertainty over its purpose. Part of the explanation for this uncertainty lies in the fact that our Bill of Rights is just an ordinary statute enacted by the New Zealand Parliament in 1990. Well, that's not really what most people think of, is it? When they hear the phrase Bill of Rights, the term conjures up the American one, a supreme law document entrenched against amendment through ordinary legislative processes and capable of being wielded to strike down offending legislation. But our Bill of Rights is just ordinary law, non-entrenched, and supposed to give way if it comes into conflict with other statutes. Statutory Bills of Rights of this kind are, by their nature, somewhat Janus-faced. On the one hand, they seem to be telling the courts to act as guardians of human rights, defending them against incursions from the state. But at the same time, they also contain within them reminders of the supremacy of Parliament and the court's constitutional responsibility to uphold legislation from challenge, no matter how morally deserving. So equivocation sits at the heart of the statutory Bill of Rights model. And in the specific case of the New Zealand Bill of Rights, this ambivalence is aggravated by aspects of its drafting history. The Act began life as a proposal for a proper Supreme Law Bill of Rights, and significant echoes of that original proposal remain in the enacted text. When the proposal failed to attract sufficient support, it was remodelled as an ordinary statute. But the drafters didn't really go back to the drawing board and build a statutory Bill of Rights from the ground up. Instead, they sort of took out a few key sections, stuffed in a couple more, and hoped for the best. The result is that the New Zealand Bill of Rights has always had something of an identity crisis. And the jurisprudence of the New Zealand courts over the last 30 years have been characterised by the slow working out of those identity issues. Well, as it happens, those 3 decades coincide almost exactly with my career in the law. The year after it was enacted, my brother Felix was one of the first, admittedly unsuccessful, litigants to rely on the Bill of Rights before the New Zealand courts. 2 years later, I returned to university to enrol for a law degree, just in time to study the first tranche of Bill of Rights cases to have been handed down by New Zealand's Court of Appeal. When I graduated a few years later, I secured a job in the new Bill of Rights team being established by the Crown Law Office to meet growing demand within government for Bill of Rights advice. Since then, my career has been one long tango with this fascinating and enigmatic instrument. Although I've written during my academic career on a number of other aspects of New Zealand's constitutional arrangements, the parliamentary rules concerning urgency, for example, and the reception of international law into New Zealand's legal system, it's to the New Zealand Bill of Rights Act 1990 that I always find myself returning. One of the contributions that legal scholars make is to assist the courts and other public officials in answering doctrinal questions about what specific statutory provisions mean and how they're to be applied. A number of these kinds of questions arise from the push me, pull you character of the New Zealand Bill of Rights. Let me give you a couple of examples. First, one section in the Act says that the courts must not use the Bill of Rights to strike down or render ineffective other statutes. But another says the courts must strive, where possible, to interpret other statutes consistently with the protected rights. So there's a line between interpretation, which is permissible, and rendering legislation ineffective, which is not. But how do we find that line? How far can or must courts bend or strain the meaning of legislation before it stops becoming interpretation and turns into repeal? A second example. The Act states very clearly, as I've said, that the courts can't strike down other legislation. But what about if they just issued a non-binding declaration or statement expressing their opinion that a statute violates the Bill of Rights? Traditionally, common law courts haven't really been in the business of issuing non-binding opinions of this kind. Their role is to authoritatively resolve legal disputes in favour of one party or the other. But the Act does contain an application section stating that it applies to Parliament, whatever that means, and some other statutory bills of rights elsewhere in the Anglo-Commonwealth expressly provide for a power to make non-binding declarations of this kind. So should our courts be getting in on the Act too? My scholarship has sought to contribute to specific doctrinal questions of this kind. One perspective that I've tried to bring to these questions is a comparative one, because there are now a number of similar statutes that have been enacted around the Anglo-Commonwealth. And there are all sorts of lessons for New Zealand in the way these instruments have been written and interpreted. But as well, I've also tried in my scholarship to contribute to the larger questions lurking under the surface about how we construct the constitutional significance of the New Zealand Act. I'm interested in how the courts and other public officials have tussled with this idea of a Bill of Rights that is in some respects constitutional, but in its form, just ordinary law. And I'm interested in the way the ambivalences in the text of the instrument and in its drafting history have opened up spaces for it to be narrated or told in multiple different ways. I wonder too if the reason I'm so drawn to the puzzle of what it means to have a statutory Bill of Rights is that in a way it functions as a metaphor for New Zealand's constitution generally. New Zealand, as you probably know, doesn't have one written higher law document that we call the Constitution. Instead, our Constitution is drawn from the myriad of laws, practices, and conventions that constitute the institutions of the state and regulate their power. In our Constitution, then, the ordinary can sometimes be constitutional, and the constitutional is always sort of ordinary. So the puzzle of the New Zealand Constitution is really just the puzzle of the New Zealand Bill of Rights writ large, a subject of endless fascination in any event for public law scholars such as me.